share capital, debentures and deposits. Share capital. Share means a share in the share capital of a company. Share capital of a company limited by shares can be equity share capital with voting rights or with the differential rights as to dividend, voting or otherwise, or it can be preference share capital. The Act defines equity through preference share capital. It says preference share capital means that part of issued share capital which carries a preferential right for dividend as a fixed amount or at a fixed rate, and also preference in respect of repayment of capital. Premium may or may not have a preference, and these things are stated in memorandum or articles. Equity share capital is indirectly defined as a share capital which is not preference share capital. Voting rights as per section 47. A member holding equity shares has a right to vote on every resolution placed before the meeting, and his voting right on a poll shall be in proportion to his share in the paid up equity of the company. Section 47. Voting rights of a preference shareholder. He can vote on a resolution that affects his rights, and he can also vote on a resolution for winding up of the company or a resolution for repayment or reduction of equity or preference share capital. His voting right on a poll shall be in proportion to his share in the paid up preference share capital of the company. When dividend on preference shares is not paid for 2 years, it gives them a special right. They can vote on all resolutions placed before the company, and the proportion of voting rights between equity and preference shareholders will be the ratio of paid up amount in respect of the two categories. Equity with differential rights issued after fulfilling certain requirements. There should be an enabling provision in the articles. Shareholder consent through an ordinary resolution required. When the company is listed, it should be through postal ballot. And the voting power with the differential rights should not exceed 74%, and the company should have a consistent track record of distributable profits for the last 3 years. The company should not have defaulted in filing financial statements for 3 financial years immediately preceding. There should be no subsisting default in respect of payment of dividend, repayment of mature deposit, redemption of preference or debentures that have become due, payment of interest on deposits or debentures, or payment of dividend. The company should not have defaulted in payment of dividend on preference shares or term loan or interest payable on the term loan or deposit, and there should be no dues as regards statutory payments and no default in crediting the amount in Investor Education and Protection Fund, and the company should not have been penalized for the last 3 years for any offence on acts like RBI Act, SEBI Act, SCRA, FEMA or any other special act. It is required that the explanatory statement going with the resolution should specify the scale or proportion of varying voting rights, effect on control and the diluted earning per share, and the shareholding pattern before and after the issue. Board's report for the year should also disclose all the relevant details. The company doesn't have a right to convert existing equity share capital with voting rights into equity share capital carrying differential voting rights and vice versa, and all other rights remain the same between equity and equity with differential rights, be it bonus shares, rights shares. Rights of a class of holders can be varied when 3/4 of their group agree to it or when they pass a special resolution in a class meeting, provided there should be an enabling provision in the memorandum or articles, and the terms of issue of such shares should not prohibit the variation. Where there are holders having 10% of issued shares of a class who didn't vote in favor of the resolution, they have a right to approach a tribunal for a revision of the decision on variation. Tribunal's decision shall be binding and final, and the company is bound to file it with the registrar within 30 days. When a company is eligible under foreign exchange management rules, it can issue depository receipts, but there should be a board resolution to that effect, which should have a prior approval of shareholders by a special resolution. Any resolution under section 62 will suffice and the depository receipts are issued by an overseas depository bank appointed by the company, and the underlying shares shall be kept in the country in the custody of a domestic custodian bank. The company is under an obligation to ensure compliance with the guidelines of RBI before and after the issue. It appoints a merchant banker to oversee the compliances. The compliance report from the merchant banker presented to the board at its meeting held immediately after closure of the issue. The depository receipts may be issued against new shares or against shares already held by shareholders. The underlying shares shall be allotted in the name of the overseas depository bank. The holder of a GDR can convert it into a share and then become a member of the company. Until such time, voting rights in respect of GDR are exercised by the overseas depository. The proceeds of the issue shall be remitted to a bank account in India, or it can be deposited in an Indian bank operating abroad. The provisions as to prospectus are not applicable in respect of offer document of GDR. Regarding employee stock option scheme, a listed company required to comply with SEBI Employee Stock Option Scheme guidelines, under which an employee means a permanent employee of the company working in India or outside. He may also include a director of a company, whole-time director or not, but excluding an independent director. An employee of a subsidiary or of a holding company is also included, but the definition doesn't include an employee who is a promoter or a person belonging to promoter group, or a director who directly or indirectly holds more than 10% of the equity shares of the company. The explanatory statement to the shareholders' resolution shall cover extensively the number of stock options, classes of employees, the appraisal process for eligibility, requirements of vesting and the period of vesting, exercise price, exercise period, process of exercise, lock-in period, and conditions under which option vested in employees may lapse, along with the time period to exercise the vested options on termination or resignation of employee. Other unique features of the scheme: the minimum period between grant of option and vesting of option will be 1 year. Freedom to specify lock-in is with the company. Employees will not have a right to receive dividend or vote till the shares are issued. In the event of death, options granted shall vest in the legal heirs. Options granted cannot be pledged, hypothecated or mortgaged, and in the event of resignation or termination, options not vested shall expire, and there will be extensive disclosure in the director's report for the year on the details of the employee stock option scheme. Sweat equity is normally issued out of a class of shares already issued, subject to conditions. It has to be authorized by a special resolution, and the resolution specifies the number of shares, current market price, consideration, and the class or classes of directors or employees to whom they are required to be issued, and where the equity shares are listed, the sweat equity will be issued in accordance with SEBI guidelines. Sweat equity shares will rank pari passu with other equity holders as regards rights, limitations and restrictions. They are issued by a company to its directors or employees at a discount or for consideration other than cash in return for know-how, intellectual property rights or value additions. Employee means a permanent employee working in India or outside, and a director can be whole-time or non-whole-time and includes director of a subsidiary or a holding company. The explanatory statement is required to include details regarding justification for the issue, class of shares, total shares, and the class of directors or employees, their names and details, principal terms, consideration, diluted earning per share, etc. The sweat equity shares to be issued at a price determined by a registered valuer. A summary of the valuation report shall be sent to shareholders along with the notice. The special resolution, as passed, will be valid for allotment for a period of 12 months from the date of passing. Annually, the amount of sweat equity shares issued cannot exceed higher of 15% of existing paid up capital or value of rupees 5 crore. Overall ceiling is it cannot exceed 25% of the paid up capital at any time, and the shares are locked in and non-transferable for a period of 3 years from allotment, and the director's report for the year will make a detailed and comprehensive disclosure on various aspects of the scheme. Alteration under section 61 permitted if authorized by articles by altering the memorandum of association in a general meeting. It involves increasing authorized capital, consolidating and dividing the shares into shares of a larger amount, subdividing the shares into shares of a smaller amount, or cancelling shares which have not been taken up and diminishing the amount of share capital by the amount of shares so cancelled. For every alteration, notice to be given to registrar, and alteration includes mere cancellation but no reduction of capital. It needs approval from tribunal wherever it adversely affects voting and other rights of shareholders. A company can increase its subscribed capital by way of issuing further shares to the existing shareholders in the ratio of the paid up capital by way of a letter of offer which specifies the number of shares offered, and it gives a timeline of 15 to 30 days to accept and act on the offer, within which if the offer is not accepted, it shall be deemed to be declined. The offer also is deemed to include a right to renounce in favor of any person. After the expiry of the time frame, Board of Directors at their discretion may dispose of the shares not taken up by the shareholders. Further issue of shares to other than existing shareholders is permitted with the help of a special resolution in three situations. One, under a scheme of employee stock option. Second, under a prospectus based on value determined by a valuation report, or increase of subscribed capital by way of the debentures and loans which were raised in the past under a special resolution passed which authorized their conversion into equity. Reduction of capital under section 66 is a two-step process: one, special resolution, and confirmation by the tribunal. A company can extinguish or reduce liability in respect of share capital not paid up, or it can cancel paid up share capital to the extent it is lost or unrepresented by available assets, or it can pay off any paid up share capital which is in excess of the requirements of the company. Once this is done, it can alter its memorandum by reducing the amount of share capital and the relevant shares. However, the tribunal may grant confirmation only if it is satisfied that the debt or claim of every creditor of the company has been secured and protected. The reduction has certain strict steps to be followed. No reduction shall be made if the company is in arrears in repayment of deposits or interest payable on them. The company has to be in conformity with accounting standards and other provisions of the Act, and a certificate from the auditor is to be filed with the registrar and the tribunal. The company shall deliver a copy of the order of the tribunal to the registrar within 30 days of its receipt, and the ROC shall issue a certificate thereupon. Where the name of any creditor was not entered on the list of creditors prior to approval of the reduction, every member on the date of registration of the order by ROC shall be liable to contribute. When securities are issued at a premium, the premium is credited to securities premium account. The securities premium account may be applied for specific purposes, 5 in number, towards issue of fully paid bonus shares, in writing of preliminary expenses, for purchase of its own shares under section 68, or for writing of expenses, commission or discount on issue of shares or debentures, or in providing for premium payable on redemption of preference shares or debentures. Where it is applied on any other purpose than the 5 above, the provisions relating to reduction of share capital shall be attracted. Except for issue of sweat equity shares under section 54, a company shall not issue shares at a discount. Any share issued by a company at a discount shall be void, and the company is liable to refund all monies received with the interest of 12% per annum from the date of such issue. A company may issue shares at a discount to its creditors only when its debt is converted into shares in pursuance to a statutory resolution plan or debt restructuring scheme under regulations of RBI. Subject to certain conditions, bonus shares can be issued under section 63 out of free reserves, securities premium account, or capital redemption reserve account. The conditions are: there should be enabling provision in the articles, and it has been authorized in a general meeting based on a proposal by the board, and the company has not defaulted in payment of interest or principal in respect of fixed deposits or debt securities, and also the company has not defaulted in the payment of statutory dues like provident fund, gratuity and bonus, and before issue of bonus shares, the company shall have converted all its outstanding partly paid up shares into fully paid up shares. No issue of bonus shares shall be made by capitalizing reserves created by the revaluation of assets. The process of buyback is subject to certain restrictions. A company can purchase its own shares or securities from out of free reserves, securities premium account, or proceeds from issue. The buyback has to be authorized by its articles. A special resolution is required to be passed authorizing the buyback. However, if the buyback is 10% or less of the paid up capital and free reserves, just a board resolution is sufficient, and the maximum limit on buyback anytime is 25% or less of the aggregate paid up capital and free reserves. Secured and unsecured debts after buyback should not be more than twice the paid up capital and free reserves. The shares covered under buyback need to be fully paid up. If listed, the buyback has to be in accordance with SEBI regulations. A declaration of solvency signed by at least 2 directors to be filed with SEBI stating the company will not be rendered insolvent within 1 year from the date of declaration, and every buyback has to be completed within a year of the special resolution or board resolution. Buyback may be effected from existing shareholders or from the open market, and once completed, the company shall physically destroy the securities within 7 days of the last day of buyback, and from the closure of one buyback to the commencement of another buyback, there should be a lapse of a minimum of 1 year. A return containing the particulars of the buyback shall be filed within 30 days of completion with the registrar. No company shall purchase its own shares if it has defaulted in repayment of deposits, interest payment, redemption of debentures or preference shares, payment of dividend to any shareholder, or repayment of any term loan or interest thereon. No company shall purchase its own securities where it has not complied with the provisions of Section 92 for annual return, Section 123 for dividend declaration, Section 127 for dividend payment, and Section 129 for financial statements. Debenture is an instrument evidencing debt. It may constitute a charge on the assets of the company. It is issued after approval by a special resolution from members. It will have option of convertibility on redemption wholly or partly. A debenture shall not carry any voting rights. Secured debentures are issued subject to terms and conditions. A company shall create a debenture redemption reserve to be used only for redemption of debentures, and it is created out of profits available for payment of dividend. The duration of a debenture is not to exceed 10 years, but in case of infrastructure companies, it can be up to 30 years. They are secured by a charge on the properties of the company or its subsidiary or holding or associate companies for due repayment of the debenture amount and the interest thereon. Company to appoint debenture trustee before the issue of the letter of offer and execute a debenture trust deed within 60 days of allotment, and the debenture trustee is required to protect the interests of debenture holders and redress their grievances. Section 44 of the Companies Act says shares or debentures or other interest of any member in a company shall be movable property transferable in the manner provided by the articles of the company. Debenture trust deed is a deed between the company and the trustees. Company mortgages to the trustees all the existing fixed plant and machinery and fixture as a security for due payment of principal with interest and other charges. Monies due to the debenture holders shall become immediately payable in the following eventualities: when the company makes a default, or the company ceases to carry on its business, or an order has been made by the court for winding up of the company, or it is certified by an auditor that the company's liabilities exceed its assets, or in the opinion of trustees, the security of debenture holders is in jeopardy. The trustee shall enter upon and take possession of the mortgaged premises as soon as the security is enforceable. He shall forthwith take steps for the purpose of determining whether the business may be allowed to be carried on, or the mortgaged premises shall be realized by sale or otherwise. A trust deed shall be open for inspection to any member or debenture holder of the company. A copy of the trust deed shall be forwarded to any member or debenture holder at his request within 7 days. A debenture trustee is required to be appointed before the issue of prospectus or letter of offer. His name appears in the letter of offer and in all subsequent communications. His written consent will be obtained before appointment, and it will be stated to that effect in the letter of offer. The trust deed in favor of debenture trustees will be executed within 3 months of the closure of the issue. The charge or mortgage created in favor of debenture trustee can be on any specific movable or immovable property. A trustee may be removed when consented by minimum of 3/4 in value of debentures. To ensure debenture trustee remains objective and impartial, he shall not be appointed as such if he is beneficially holding shares in the company. or he is a promoter, director or key managerial personnel of the company or its subsidiary or associates, or he is beneficially entitled to monies otherwise than as remuneration payable, or he is indebted to the company or its subsidiaries or associates, or he has furnished any guarantee in respect of the principal debts of the company, or he is a relative of any promoter or any person who is a director or key managerial person of the company. A debenture redemption reserve is created out of profits of the company available for payment of dividend. It shall not be less than 15% of the debentures maturing during the year ending 31st March of the next year. The DRR shall be created in respect of non-convertible portion of the debenture issue. The amount credited to DRR shall not be utilized except for the purpose of redemption of debentures. The debenture redemption reserve will be maintained in deposits with any scheduled bank or in unencumbered securities of the central or state government. Tribunal helps whenever the assets of the company are likely to become insufficient to discharge the principal. The debenture trustee may file a petition before the tribunal, which after hearing may impose restrictions on incurring of any further liabilities by the company as felt necessary. Where a company fails to redeem or pay interest when due, the tribunal may on application and after hearing direct the company to redeem the debentures with interest forthwith. Section 73 to 76 of the Companies Act, read with Companies Acceptance of Deposit Rules, contains conditions for acceptance of deposits by companies. Section 2, subsection 31 says deposit includes receipt of money by way of deposit, loan or in any other form by a company, but it doesn't include such categories which are prescribed under Rule 2, subsection 1, clause C of the Company's Acceptance of Deposit Rules 2014. Two types of depositors: member under section 73 subsection 2 and any person who has made a deposit as per section 76. Section 76 talks of eligible company as a public company which has got a net worth of not less than rupees 100 crores or a turnover of not less than rupees 500 crore. Such an eligible company, before making any invitation to the public for acceptance of deposits, obtains the prior consent of the company in general meeting by means of a special resolution, and such a resolution is filed with the registrar before proceeding further. Section 73 subsection 2 provides for accepting deposits from members subject to fulfillment of certain conditions, passing a resolution in general meeting, filing a copy of the circular along with the statement with the registrar within 30 days before the issue, depositing every 30th April 20% of the deposits maturing in the following financial year under the bank account, deposit repayment reserve account in a scheduled bank, the amount not to be used except for repayment of deposits, arranging for providing security for due repayment of amount of deposit and interest thereon. Where a company doesn't secure the deposits shall be termed as unsecured deposits. A public company having specified net worth or turnover under section 76 subsection 1 may accept deposits from persons other than its members, but it should obtain a credit rating from a recognized credit rating agency and inform the public about the rating given to the company at the time of invitation of deposits, and the rating should be obtained for every year during the tenure of deposits. The company accepting secured deposits from public has to create a charge on its assets within 30 days. A public limited company is permitted to accept or renew deposits for 6 months and above up to 36 months, and the company referred in 73 subsection 2 allowed to accept from members not to exceed 10% of its paid up share capital and free reserves and security premium account. Companies referred to in 76 subsection 1 to accept deposits from public not to exceed 25% of the aggregate of the paid up share capital, free reserves and securities premium account. A company accepting deposits shall dispatch a circular to its members or publish it as an advertisement, and such circular shall be signed by a majority of directors, filed with ROC at least 30 days before its issue, and such circular or advertisement remains valid for 6 months from closure of the financial year. The company will appoint a trustee for depositors for creating security for its deposit, and a deposit trust deed executed at least 7 days before issue of circular. Security will be created in favor of a trustee by the company on movable or immovable property for due repayment of the amount of deposit and interest thereon. The company shall maintain a register of deposit entering particulars of each depositor within 7 days of issue. It shall file a return of deposits with the registrar on or before 30th day of June every year and furnish information as on 31st day of March duly audited. It shall furnish deposit receipts to the depositors for the amount received within a period of 21 days from the date of receipt of money or from the date of renewal. Company shall maintain liquid assets under deposit repayment reserve account on or before 30th April of each year with any scheduled bank, and it shall be utilized for repayment of deposit. Any contravention of section 73 or 76 will render the company liable for action under section 447. Equity share capital and preference share capital are the two kinds of share capital of a company. A company is prohibited from issuing shares at a discount as it is void. A preference share is redeemable and it cannot exceed 20 years in its life from the date of issue. Any resolution which authorizes issue of preference shares shall indicate whether the payment of dividend is cumulative or non-cumulative. Wherever the preference dividend is remaining unpaid for a period of 3 years or more, the preference shareholders get a right to vote on all the resolutions placed before the company in its general meeting. Preference shareholders find a place in the register of members on par with the equity shareholders. Equity share capital can have option of with voting rights or with differential rights. Differential rights pertain to dividend and voting. The holders of equity shares, even where they are with differential rights, their right to bonus and rights remains intact on par with the other equity shareholders. A company is prohibited from converting one class of equity into another. That is, existing equity shares with voting rights cannot be converted into equity carrying differential voting right and vice versa. They should continue in their original classification. Any share certificate to be delivered by the company within 2 months from the date of allotment. Wherever the company doesn't apply the common seal, the share certificate has to be signed by 2 directors jointly or by a combination of 1 director and the company secretary where there is one. Every company limited by shares will maintain its register of members in form number MGT1. A company may close its register of members for a maximum period of 45 days in aggregate in each year. Securities premium account can be used mainly for 3 purposes: to write off preliminary expenses, to buy back shares of the company, and also to issue bonus shares. Bonus shares can be issued out of share premium account, but they can also be issued out of free reserve and capital redemption reserve. Where reserves arise out of revaluation of assets, such reserves cannot be used to issue bonus shares. In case of sweat equity shares, there is a restriction or ceiling of 15% of existing paid up share capital in a financial year. The sweat equity shares at any point in time cannot exceed 25% of the paid up capital of the company. Sweat equity shares have got a lock-in of 3 years from the date of allotment, during which they cannot be transferred. A company can have private placement of equity share, preference share or debenture, and in a financial year for each of these categories the private placement can be made to 200 persons in aggregate for each. The value of invitation per person should carry an investment size of a minimum of rupees 20,000 of face value. A company which has defaulted in the repayment of deposits accepted by it cannot exercise the right of reduction of its capital. A buyback exercise has to be completed within 1 year from the date of passing the authorizing resolution. The resolutions might have been passed in the general meeting or by the board, but it has to be acted upon within 1 year. There should be a cooling off period between 2 buyback periods to buy back. Once a company buys back, it cannot make a further issue of similar type of securities within a period of 6 months. There should be a gap of 6 months before any other issue of similar securities is made. Section 2 subsection 30 defines debentures as including debenture stock, bonds or any other instrument. It evidences a debt. It may or may not constitute a charge on the assets of the company. Section 44 states shares or debentures shall be movable property and they are transferable as per provisions of articles of the company. No company can issue a debenture with any voting rights. Voting rights are for equity shareholders only. The date of redemption not to exceed 10 years, and a company may issue convertible debentures also, which can be converted either wholly or partly, but such issue has to be approved by a special resolution of members. Debenture trust deed is made between issuing company and the trustees in form SH12. A trust deed will be opened for inspection to any member or debenture holder as if it is a document similar to register of members of the company. A company to appoint debenture trustee before issuing the prospectus or letter of offer, and a formal debenture trust deed has to be executed within 60 days after the allotment of debentures. A person shall not be appointed as a debenture trustee if he is interested in the company or if he is a promoter, director, key managerial personnel or an employee in the company, its holding company, its subsidiary or associate company. Before the appointment, a written consent shall be obtained from him and the letter of offer of debentures shall contain a statement to that effect. The trust deed cannot contain any provision exempting a trustee from any liability for breach of trust, as such exemption shall be void unless it is agreed upon by a majority of 75% of the debenture holders in value. A trustee may be removed only if approved by the holders of once again 75% in value of the outstanding debentures, and it should be done in a formal meeting of debenture holders. Debenture trustee has got two main duties. One, to ensure that the assets of the company and of the guarantors, if any, they are sufficient to discharge the interest and principal amount at all times, and second, that such assets are free from any other encumbrances. A public company having a net worth of 100 crore or a turnover of not less than 500 crore is eligible for making an invitation to the public for acceptance of deposits. Net worth of 100 crore or turnover of not less than 500 crore. The company has to obtain a rating which confirms adequate safety. It has to be obtained from a credit rating agency and it has to be informed to the public at the time of invitation of deposits from them. Company to execute a deposit trust deed at least 7 days before issuing the advertisement inviting the deposits. It should be in form DPT2. Every company which accepts deposits from the public which are secured within 30 days of such acceptance has to create a charge on its assets covering the entire amount not less than the amount of deposits. A company can accept deposits for a term which is not less than 6 months up to and not exceeding 36 months from the date of acceptance or renewal. Company can accept deposits from its members under section 73 subsection 2 and it shall not exceed 10% of the aggregate of paid up capital plus free reserves plus securities premium account of the company. Deposits from members. Deposits from public under section 76 subsection 1 not exceeding 25% of share capital, free reserves plus securities premium account. The company on acceptance or renewal of deposit has to issue a deposit receipt to the depositor or his agent within a period of 21 days for the amount received. Whenever there is a withdrawal which is premature withdrawal at the request of the depositor after the expiry of 6 months from the date of such receipt but before the expiry of its regular period, company can reduce the rate of interest. It is not can, it is shall. Company shall, it is mandatory to reduce the rate of interest by 1% from the fixed rate. Whatever rating the company obtains, it has to obtain every year during the currency of the deposit.